Good morning, good afternoon to those who are in Mauritius. Welcome to the Judicial Committee of the Privy Council, where today we are hearing an appeal from the Court of Civil Appeal of the Supreme Court of Mauritius in the matter of Ciel Ltd and Tropic Nits Limited against the Central Water Authority. The case concerns whether the appellants have established valid proprietary rights over shares of water in a river, the river Tatamaka and its tributary, those water shares having been granted to a predecessor in title of the first appellant by a Supreme Court order of 1888, which is now untraceable. I'm Lord Lloyd Jones, and today I am sitting with Lady Arden.
Good morning, good afternoon.
Lord Burrows.
Good morning and good afternoon.
Lord Stevens.
Good day.
And Lady Rose.
Good day.
The appellants are represented by Maxime Sauzier, State Counsel, and Deepti Bismuhan, and the respondents are represented by Anwar Moulin, State Counsel, and Jennifer Confortium. Mr. Sauzier.
Good afternoon. Just a small rectification. It's Miss Natasha Biari Pare who is assisting me today.
Thank you.
Thank you, my lords. May I start, my lords?
Yes, please.
Right. My lords, you will see that the grounds of appeal are to be found at pages 987 and 988 of the bundle, and there are 8 grounds of appeal. I propose, first of all, to deal with the issue of ownership of land and water. And if I may, I will deal with grounds 1, 3, 4, and 5 together. I do believe that these 4 grounds deal with this issue of ownership of water. If we go back in time, my lords, in 1974, there was a société, which is referred to as a société de fait, which existed since the 1st of January 1973, and a deed was drawn in 1974, document K, which is at page 453 of the bundle. And the société was embodied in a deal, and it was then known as Société Refac. According to this deed, this document G, the object of the Société Refac was to continue, I stress on the word continue, to own, to possess, and operate the sugar factory, formerly the property of Réunion, as well as the equipment and machinery forming part thereof, and the land on which it stood, together with neighboring lands of 14 acres and 16 perches. This is what we see in this document. In 1987, Société Refac, as it was known, sold the land to Ciel, appellant number 1, and the deed of sale is to be found at page 491. It was labeled document K. And when we look at this document, my lords, at page 495 are included in the sale all the water rights. I do believe that you can read that 7 pages from the bottom, but it is in French. The translation is to be found in the written case at page 1017, bottom of 1017, and it reads, the water rights of which the lands presently sold as the right as shall be seen hereunder, and generally all that may depend or form part thereof. This So the sale of the land to Ciel, to appellants number 1, was the land plus water rights. More precisely, when we go down this page, that is page 495, your lordships will see that there is a heading droit d'eau, which is in fact the translation of water rights. And when we turn the page, it makes mention of a report. This is the famous report which has been misplaced, of Mr. Surveyor Maillard in 1888, according to which the divisible waters of both rivers, that is Tatamaka River and its affluent, Saint-Martin River, have been divided into 67 shares. Out of these 67 shares, 16.035 shares from Tatamaka and 6 from Saint-Martin were allotted to Réunion. So I have the picture in 1888. We've got 22.035 shares which have been allotted to Réunion. Now, this report has been homologated before the Supreme Court, and it bears a number. You will see that it has got a Supreme Court record number, 23777. Unfortunately, as your lordship rightly pointed out at the outset, the report cannot be traced. I am afraid that the blame cannot be laid on the respondent or the appellant, because after all, the Supreme Court is a court of record and there is no explanation forthcoming from them. So be it as it may, there is no report, but there is reference to the report. Now, next, subsequent to that, report of Mr. Maillard, your lordships will see that mention is made of another case which is a case of 1939, Supreme Court record 20141. This report, it is in French in the title deed, but your lordships can have a look at document D, which is at page 429 of the bundle, and this is an exact replica of what we've got in the title deed. So 429 is the report of Mr. Swanland Surveyor Francis Hall, as he then was, dated the 2nd of May 1938, page 432. And if we go through the report, your lordships will see that the 22.35 cubic feet of water or shares were insufficient for Réunion. And the author of this report, Mr. Hall, from pages 429 to 432, he goes on to say that the other riparian owners would not be affected if a surplus water was to be given to Réunion. But there are conditions attached to this request of surplus water. I won't go through them, they have been listed in this document, but there is one part which is important, my lord. When we look at page 430, down the page, if we go through the last paragraph, this last priser and the priser above, Vaqua Village, shall, under the suggested conditions, have at their disposal a larger share of water, as the factory of Réunion shall return the rivers not only the surplus waters taken by this application, but also the 20.035 shares which are its property. So I just pause there, because Mr. Hall, when he's addressing the Supreme Court for surplus water, clearly defines the 22.035 shares of water which have been granted to Réunion since 1888 as Réunion's property. This fact, my lord, is of utmost importance, and if I may, it has been accepted by the respondents, because when we look at the document which has been produced by the respondent. It is document BJ. It is at page 596 of the bundle. In fact, it is dated 1994, and it is signed by Mrs. Boudou, the main witness for the respondent, and your lordships will see that she makes history of the various grants of water, and it is absolutely clear. I won't read through the whole page for the sake of not wasting your time, that it is clear that in 1888, an amount of water, so much shares were granted and allocated to Réunion, and that there was a sale from Refac to Ciel, including the water rights. Now, this also at page 431 in the report of Mr. Hall, I go back to the report, your lordships will see at page 431, 4 lines from the bottom, I read the words, and allowing the 22.035 shares which belong to Réunion. So there is once more a clear indication of title as to these shares of water. But if we go further, when Mrs. Boudou was cross-examined, at page 208 of the brief, I make just reference to page 208 of the bundle. Bottom of the page, I'm making reference to this report of Mr. Hall, and your lordships will see that this is the conclusion which Mr. Halls arrived at after reading the document which was homologated in 1888. The answer is clear, yes. That is Réunion, that is Estate Réunion was since 1888 entitled to 22.035. We turn the page, that's right. So it is unequivocal for me that it was absolutely clear that from 1888, Réunion was entitled to this.
And whose
Now,
evidence is that, Mr. Sazier?
I'm sorry, Mrs. Boudou.
Mrs.
Boudou,
Thank you.
the
Yes.
first witness to depone on behalf of the respondent.
Thank you.
Now, I'm sorry, my lord.
Thank you.
Just before we leave page 429, could you just help me in relation to paragraph 5 on page 429? That is the were the 500 arpents in 1888 under cultivation and subject to irrigation under cultivation. It looks as though there's been an increase in the amount of sugar being produced by virtue of the land being parceled out, which has 2 effects. First of all, if there was a factory in 1888, it must have got larger between 1888 and 1939. And secondly, that there are a whole lot of areas of land which were subject of irrigation in 1888, which no longer belong to Réunion.
My lord, there is, I have no answer for that. There has been no evidence, but if I may, it is correct to say, I was going to make reference to that, in 1939, when Mr. Hall makes the report, he draws the attention of the court to the effect that the original acreage of land has been diminished, and that there has been parcellation of land. That's for sure. But there is no evidence in the court record that it was 500 or 100 acres at a certain stage. Somebody did mention. But it is correct to say that in 1939, there had been parceling of land prior to the request for surplus water. May I proceed, my lords?
Yes, thank you.
Thank you. Now, it is obvious, my lord, that the second application of 1939 concerns surplus water. But what is relevant is that in the statement, in the rule of court, which is at page 436, is that when we have a look at the last 3 lines, page 436, roof court, that the surplus water will be conveyed to the factory by Réunion Canal, which therefore existed and no doubt was constructed to carry the 23.65 shares of water from Tatamaka and River Saint-Martin. Now, the obvious question is concerning the regularity of the transfer to Ciel and respondent number 2. I want to stress, my lords, that I agree that it is Floréal respondent number 2. They applied for a lease. They were lessees of appellant number 1. They applied to the respondent for water rights. This is admitted. It is admitted that there was an agreement between appellant number 2 and the respondent for the grant of water. Thirdly, that there was an agreement with regard to a price, ₹1.50 per cubic meter, and also that there was a report from Sigma which was sent to the respondent. The report is at page 5 to 9 about experts on behalf of respondent number 2. Now, the transfer of water rights to Ciel is being challenged, or has been challenged, by the respondent on the authority, it is said, of settled case law, according to which the waters of both rivers are public property, that is, du domaine public, and as such may only be made use by the proprietors of the lands bordering the river in the manner prescribed by the Rivers and Canals Act 1863, to which I will make reference later on. The rights to the water enjoyed, according to the respondents, by the borderers are attached to their land and cannot therefore be transferred separately from the land. Our case, my lords, concerns the status of the water which has been conveyed to the land of Ciel through Réunion Canal. So I will try to make the difference between the rivers and the canals. And the obvious place where to start is the Rivers and Canals Act.
Mr. Sauzier, can you tell it, Mr. Sauzier, do we know the date of the construction of the canal?
No, no. There is nobody old enough, my lord, to depone us to that. We surmise that it is in 1888. Mr. Roger Noël, who deponed on behalf of the appellant, did say that he'd been working there for 40 years and he's known the canal since he was working there. But there has been no evidence or counter evidence to suggest that it was otherwise. It was the property of Réunion.
Thank you.
My lord, now the obvious place to start is the Rivers and Canals Act, which is at page 1119, tab 2, for my learned friend appearing for the respondent, tab 2.
It's 1119.
1119, Rivers and Canals Act.
Yep.
Now we all agree, my lords, that this act is still in force, and reference has been made to same in a number of judgments, and even in these judgments, that the provisions are still in force. If we go, my lords, to page 1121, section 3, I read, subject to this act, all rivers and streams are public property du domaine public. I stress on the words subject to this act. The Rivers and Canals Act, in fact, there are two parts to it. The first part, part 1, makes provisions for rivers and streams. And the rivers and streams are defined in section 2 of the Act, which is at page 1120, 1120. Rivers and streams include all natural rivers of water and watercourses, but does not include any artificial watercourse. Part 2 of the Act deals with canals, and canal is described in part 2.1 of the Act as including all artificial watercourses belonging to any corporation or community of riverains, but does not include any private watercourse belonging to any individual. Now, Lords, the Act does not say one thing. Where the waters running into a canal are to come from. This is one thing it doesn't mention. But if I may refer your lordships to two judgments, in fact, the issue has been analyzed in two judgments. The first one, the two judgments are very old judgments, unfortunately. The first one being the judgment of Constantin against Chaline. It is to be found at page, more specifically at page 1254. It is tab 14 for my little friend, if he is with me. And if I may read a very small excerpt, paragraph 2, my lords.
Forgive me, where does this start?
It starts, I'm sorry about that, my lord, 1250. This is the case of Constantin and Chaline, 1250.
Yes.
I'm sorry about that, my lord. So if we turn the page to 1254, second paragraph, the 11th line. I read, again, it is to be noted that in chapter N, second of the ordinance, which regulates the canals of the colony, that is, runs of water taken off from the rivers, the rights of parties are to be determined according to their written or prescriptive title. So it is obvious that the pronouncement in this judgment is clear, that is, the waters are drawn from rivers onto canals. Same observation in the case of ex parte Colin, for my friend Moulin, tab 15, page 1264. And more specifically, my lords, at page 1271. Now, page 1271, the second paragraph, seventh line. I read, there is a part of this ordinance which contains a code of regulations for the canals of the colony. It is well known that the water of these canals is taken from our rivers at certain points to supply certain districts or estates with water. So I just wanted to state the obvious, that the water flowing into a canal comes normally from rivers, as laid down in these two judgments. So Réunion Canal, now we come to Réunion Canal, which takes its water from Tatamata.
It goes on to say, Mr. Sauzier, that it may seem strange that water derived from rivers which are public property should, by transference to a canal, become private property.
Yes, I'm coming to that for the issue of privatization of water in a few minutes.
Right.
I was coming to the same part. I will.
Thank you.
So my submission, my lords, would be that Réunion Canal is regulated by part 2 of this act. And it is obvious that when your lordship earlier on asked me a question concerning when was the canal built, the only part of the evidence that we've got concerning whether it was man-made or not, if I may, is at page 210 of the bundle. 210, when Mrs. Boudou was deponing, 210. The second answer, top of the page, that it is a private canal. This is the only reference. And at page 223, which is more to the point, my lords, 223, Mr. Ram Kisun, a witness for the respondent, was cross-examined. And your lordships will see cross-examination by Mr. Sauzier, 1, 2, 3, 4th and 5th answer. It is line 31. My question, you describe the canal as a man-made, yes, and private. So this is the only evidence that we've got with regard to the nature of the canal and its status, that is private. Now, the next step, my lords, is obviously to go to the Rivers and Canals Act, what is provided in part 2 of the Act, that is the part dealing with canals. And at page 116, this is part 2. Section 32 of the Act. Canals shall be the property of the individuals who have the right to them and shall be used and enjoyed by them in conformity with their titles and the Act. General. Section 33, 1. Rights to canal water. 1. The rights of parties who claim portions of water from any canal on the ground of concession, not the case, apportionment or prescription, shall be determined in conformity with their written or prescriptive titles. 2. Where the rights cannot be determined on the basis of written or prescriptive title, the persons who contributed to the cost of constructing the canal or their successors in the properties through which the canal passes shall have rights to portions of the canal. So this is the law with regards to canal. Now, my lords, of course, I come to the point raised by your lordship. The next question is, how can the water running into a canal be said to be private property when the water comes from the river, the waters of which are of domain public, public property? This is exactly what then is late Justice Muir had to say in the case of Ex parte Colin at page 1271, which has just been referred to by your lordship. If I will start where I ended earlier on, it is second paragraph, page 1271, 12th line. It may seem strange that water derived from rivers, which are public property, should by transference to a canal become private property. But the first section of the Canal Code, the 31st clause of the ordinance, enacts that the canals in Mauritius shall be held to be the property of the individuals, etc., having right thereto. This is a contrast to the first clause in the Rivers Code, that they are public property. Further, as it is clear that the authors of the ordinance knew well how to express themselves when they wanted to give a right of property, it may be deduced from the fact that there are no similar words in conferring the rights of the riverains of rivers, that there are no intention to confer a right of property on them. To conclude, my lords, on this issue of ownership, I will say that the canal, Réunion Canal, has been constructed by Réunion. This, in fact, has been averred by the appellant's representative, Mr. Roger Noël, and also you will see that there has been at page 225, if I may just stress on that, Mr. Ram Kisun, when being cross-examined, there was a confusion in his mind with regard to the construction of the canal, because there were other canals in Mauritius which had been built by the respondent, but this one was not, and he rectified. He was under a confusion, what he says, and I just wish to conclude that there is no doubt that the constructors of the canal were Réunion, and the successors are today the appellant, is the appellant number one. Mr. All was perfect. Sorry, Melody.
Yeah, does it depend on how far one can take what was said in ex parte Collin? I can see that the water in the canal is private and is owned, so that the rights that people have under Part 1 of the Act to use the water, take the water for their domestic purposes, to use it for irrigation, do not apply to water flowing through a canal. They don't have those rights that are conferred in the early sections of Part 1 of the Act. But your case depends on the proposition that what was decided, or what was being referred to in that case, is that even if you have no right to divert the water into the canal, once the water is in the canal, it then becomes the private property of the owner of the canal, even if they were not entitled to take the water from the river. I mean, do you accept that that is the proposition for which you're relying on this case?
No, Melody, I would say that there must be a right to draw water. I think that there must be a right, and we say that we have had a right in 1888 when we were the owners of the then Réunion estate applied, and the report of Mr. Maya gave 22.035 shares out of 67. So our submission is that, admittedly, the document is not there to see whether there were conditions attached to it. But admittedly, we say that there was a right which was granted, that we were granted this right, and that it was the ownership of Réunion. We would not suggest that there was no right at all. On the contrary, because we say there was a right, and either by title or by prescription. And I'm coming to the issue of prescription later on, but we said very clearly from the start that this 1888 allotment did allow Réunion to have a title in the water. This is the basis of the case for the appellant. I would not suggest that any person, if he was to draw water in a canal without any authorization from the court, would be entitled to the water. I would not say that.
Well, Mr. Sosi, in that case, I'm not clear what is the relevance of the water being carried in a canal, because your case rests on the 1888 grant, not on the fact that it's subsequently carried in a canal.
Yes. When there is an application before the court, my submission is that if the water runs into a canal, it becomes private. If there has been authorization from the proper court, this is what we say. We did apply, it was homologated, and we were given X number of shares. So this water, when it comes from the river, which is public, when it comes into the canal, it becomes private. Whatever we want to do, we can do. There are no conditions attached because we haven't got the 1888, unfortunately.
But do you accept that if there were conditions attached to the use of the water by the 1888 order, that those conditions still apply to the use of the water in the canal? I'm not quite sure why it's important for you to say that the water in the canal is private. What part of your case depends on that statement?
This is what the law says, according to me. I might be. What we say is that it becomes the property of the individual when it flows into a canal. The distinction has to be made between a canal and a river. The river, it will remain public, whatever happens. But when it flows into a canal, my submission is that it is private, provided that we've got a lawful authority to draw water, which we have.
Well, so it all comes back to the authority to draw water from the river.
Yes, of course, because we say we have had the authority. To answer to your ladyship, fair enough, the document is no longer present, but if there was any breach, it would have been on the part of the respondent, if they need be, to start proceedings against the appellant for breach of conditions, which they did in this case, as far as the 1939 order is concerned, because they say in their plaintiff summons we are not abiding with certain conditions, that is to remit the water back into the river. But it is undeniable that the 1888 order grants X number of shares to the appellant. So we say that the water becomes private. Yes, my lord.
Yes, I'm also struggling with the same point that my Lady Rose has raised. Let me put it to you this way. Why isn't it sufficient for your case to have shown that you are drawing water from a private canal? Because as I understand it, you are saying that that canal is owned by Réunion and hence by the successors and is therefore private property. Why isn't that in itself enough for your case?
I think that I think that what has to be shown is that I had a right to draw water from the public, from the river.
Why is that important, given that you've already told us that it becomes private property of the canal owner once it's in the canal? Why are you placing an additional hurdle that you are requiring yourself to overcome, when on the face of it you've shown us
Yes.
that
Yes.
it's sufficient that the canal is privately owned?
Because when we, my lords, when we look at the part 2 of the Rivers and Canals Act, my interpretation at page 1126, section 32 and 33, canals shall be the property of the individuals who have the right to them. And then 33, the rights of party who claim portions of water from any canal on the grounds of concession, apportionment, or prescription shall be determined in conformity with their written or prescriptive title. So I would think that there must be some sort of right to draw water from a river, because river is public, but the public, the issue of the public property cannot be transferred. I cannot be granted public property. So it has to become private at a certain stage. And for me, the conversion is at the connection between the canal and the river. But when it enters the canal, it becomes private. And then the respondent cannot have any right to claim levies or duties on this water.
Lord
Yes,
Stevens
my lord.
has a question.
If I understand you correctly, if the extraction of the water from the river into the canal is not permitted, hasn't been granted, is unlawful, then your claim fails.
I would have thought so, my lords, because I will make reference in a few minutes to the case of Maga, where the same issue was addressed.
Yeah. And then could
I think that
ask
there
you,
must be. Yes, I'm sorry. No. I will read the part of the judgment where His Lordship addresses this point. Yes.
Yeah. And therefore, the knitting and dyeing factory obviously wasn't there in 1888.
No. Yes.
Was
It
there
was a
any
sugar factory.
authorization for that industrial use? And if not, is that a requirement of the legislation that you have authorization for a particular industrial use?
I would say no, my lord, because the water is private and there were conditions probably attached to the 1888 order. We haven't got them. It was for an industrial purpose because it was a sugar factory. Admittedly,
Well,
there was no dyeing factory.
How do we know that? How do we know there was a sugar factory there? Yeah, how do we know that?
Was Réunion sugar factory.
Well,
There were,
but where's the evidence of that?
there is no there is evidence in the report of Mr. in the REFAC. I'm sorry. Yes, in 1977, the first part of it that I made reference at the when the society was created, is continue to operate and to own. That is, yes, there is no evidence that in 1888 the factory was, but history says that, but there is no evidence. Fair enough.
Yeah. Yeah. But for all we know,
this was the, yeah.
For all we know, it was purely for irrigation in 1888.
I would not think so, no, because your lordships will see that even in the plate with summons, if I may go as far as the plate with summons, at page 9 of the brief, A8. This is the argument of the plaintiff, now the respondent. This concerns the 1939 order that the plaintiff further argues that the defendants are not entitled to use the water for any purpose other than for the working of a sugar factory.
Yeah, well, there's no doubt there was a sugar factory in 1939, and there's no doubt there was a canal in 1939. But at present, I'm having difficulty in seeing where the references in the documents are to the Supreme Court authorizing a canal. There are lots of references to shares in the water in the river, but in order to extract the water from a river by machinery or by other means, you have to get the permission of the Supreme Court. And so I haven't got a history as it yet in my mind or evidence that there was actually authorization of the canal.
Yes, we have the order of 1888. We've got the shares. We've got the for water. Yes, at page. I would say, my lords, that when the order of 1888 was granted, that is the report of Mr. Maya, this was for the specific purpose. That is to convey water, so many shares of water, to Réunion. And it is admitted that water was conveyed through a canal. There is evidence to the effect that this canal has existed since time immemorial. As far as Mr. Noel is concerned, I don't think this was disputed, that the ones who built the canal was Réunion. Now Ciel standing in the shoes of Réunion.
But his evidence was that he'd been there for 40 years, and
yes. Right, there would be no evidence.
That doesn't take us back to 1888.
No, certainly not. Certainly not. Yes.
The map which we have at page 376 shows the canal.
Yes. Yes.
Do we know the date of that map?
This was annexed to the report of Mr. Document 7. There is there is only one issue. If we look at the 376 on the left, you've got 1810, but I won't venture to say that it has been there since 1810, certainly not. No. No, but it was certainly there in 1939, because the order of the court, to which I referred earlier on, at page, in fact, this page, Malone, this report is the same as the one at document D. which is at I made reference to this document earlier on at page 4 to 7. In fact, this is the same report, and the court order is to be found at 436.
So it's part of the 1939 order.
It is. And it is clear that in 1938, that is the time Mr. Hall made the report, that Réunion Canal existed. Because, my lords, if I may, when the order of the court in 1939 is made, it is for carrying out, that is the water, the 9/10 of the water, flowing through the aperture, now existing in the said dam, for the lower riparian owners, the water so taken shall be conveyed to Réunion Factory by Réunion Canal. So it is 1939. But the report of Mr. Hall, which is annexed to this document, speaks about the water, that is the 22.035 shares of water, which are going to be remitted back to the river. So meaning that these 20, it is at page 430, last 3 lines, Mr. Hall makes reference to both grants of water, that is the whole flow of water, being remitted back to the river. So meaning that this canal was used for the 22.035 cubic meters. This is where I made reference to it being the property of Réunion.
So,
430 and 31.
so you're saying that. So you're saying that what we learned from the 1939 order was that
Yes.
the 22.035 shares which were allotted in 1888 also had to be returned to the river, which
Yes.
indicates to me that they were not then being used for irrigation. Because
Yes.
if you use them for irrigation of the sugar crop,
Yes, there is no
you can't
return.
return it to the river. It must have been used in some kind of factory
Industrial.
process.
Yeah. Yes.
And do you accept then that the 1888 order required the water to be returned to the river?
There is no evidence as to that, my lord. There is no evidence. Yes, I would say it could make sense, yes, but there is no evidence. But in 1939, there is evidence that this share has to be returned. So yes, maybe it would not be unwise to.
I thought that your answer to my Lady Rose was that one could deduce from what was said in 1939 that the 1888 order required the water to be returned to the river, and therefore it wasn't used for irrigation. But if that is so, the 1888 order, the condition that was imposed, isn't being complied with.
Could be. Yes, my lord.
Insofar as the water isn't being returned to the river by the dyeing factory.
Yes, yes, certainly. They are being returned to the wastewater because there was a wastewater system which was, but I humbly submit that this is not part really of the case. It might be a condition which has been breached, yes, on the face of the document, but we are more talking about whether the water is private in the canal or not. Fair enough if there is a condition which is attached, but there were questions which were put in the course of the trial to the effect that there is now a wastewater system where the water is being returned polluted or unpolluted. But yes, my lord, I accept that if there is mention at page 456 that both orders of water should be returned, yes, I agree. I agree. Lords, if I may continue. on that score, on the privacy, private and public element of water. We've made reference in the written case at page 1029 of whether water in a canal could be labeled as private, being private. And your lordships will see that there are two notes, specifically note 166 at page 1030. It is French, but the translation is at page 1031. 166. Principle: the owner of a private property can build on his land a navigation or irrigation canal which is private. The one who builds the canal is at the same time the owner of the waterbed and the water in the canal. This is the element of privacy. And also at note 173, it is in French at page 1030, but in translated at page 1031. Lord, the Act, the Rivers and Canals Act, also speak about prescription. And this issue has been addressed at page 1035 in our written case. And at paragraph 57 of the written case, your lordships will see that we've made reference to two articles of the Civil Code, Article 2219 and Article 2262, and the translation is to be found at page 1036. In a nutshell, if I go to 1036, Article 2219 says, the acquisitive prescription is a means of acquiring property or its dismemberment through the effect of possession. And 2262, the one who claims to be eligible for the 30-year prescription is not under the obligation to show the proof of ownership. My lords, I will simply say that there has been no challenge of ownership of this water from 1888 to 1987, just shy of 100 years. And this was borne out of the evidence at page 214. The third answer from the top of the page. The first time that there is any issue is on the 2nd of April 1987. So we are just short of 100 years. Just to finish on that specific point, in the French jurisprudence that has been referred to in our written case at page 1030, your lordships will see that there is also reference to note 176, bottom of page 1230, and the translation is to be found at page 1032, section 1. Sorry, page 1032, yes. Finally, and of course, the usage of the waters in the private canal can be acquired by convention or through inheritance from the father of the family. This right of usage can also be acquired through prescription after 30 years and within the limits of the latter, that is, for the sole usages who have constituted useful acts of possession and in respect of the sole owner against whom these acts were carried out. So my submission to your lordships is that there has been no inquisition or no interference of any sort as far as the ownership of water and use of water, I may say the use of water over 100 years.
So do you say that the consequence of that is that if any conditions had been attached to the use of the water, those have sort of lapsed in some way after 30 years? Or what is it that you have acquired by prescription exactly?
The ownership of the water. If the conception of privacy of water running through a canal is accepted, if this use of the water has not been challenged over 30 years, if it has been legally obtained, my submission to your lordships is that there is no, in our case, I think there is a title, but if there was no title, because we've got a title which has been homologated in 1888, a right to draw the water, for me, if after 30 years there has been no interference of whatever nature on the part of any authority, this right becomes prescriptible after 30 years. This is what I'm suggesting. Yes, my lord.
Do you agree that you can't have a prescriptive right in relation to the water when it's in the river?
Of course, of course. It is domain public. Oh, yes.
Yeah. And so we're back to the same question. That really, whether you gain ownership of the water through building the canal or through prescription is neither here nor there, unless you have a right to extract the water from the river.
Yes, of course.
Yep. Yep.
Yes. Agreed.
Yep. And that all depends upon the
This is where we go back
1888.
to it.
Yeah.
Yes.
Yeah. Okay.
But if the canal existed in 1888 and the rights you obtained were known to be rights to abstract via the canal, then there would be consent, would there not, to your using the canal? And that would be
think so,
prevent the operation of prescription.
If it is known, because I would think that prescription is au vu and au su, that is known to every person that I'm using the canal. If it was hidden, I would not think that we could raise the issue of prescription. I think that this canal existed for me. We have no tangible proof, but I would surmise that it is 1888 for the transport, for the carrying the water from the river onto the canal, and the transmission from river to canal meant that with authorization of the court in 1888, it meant that the water was of a private nature, and that if we did not succeed on the question of title, we could even raise the issue of prescription because it is prescribed in the law in section 32 and 33 of the Act. This is what I'm suggesting to your lordship.
But maybe the right was given for the purpose of your using it for irrigation or for the sugar factory,
Yes.
and that those were the purposes consented to. And that once those activities...
I would certainly, yes, Melody, I would certainly not venture to say that it was for dyeing purposes in 1888. It probably was for the sugar factory and or irrigation. But this document is not available today. And if there was a breach, I think it would have been the duty of any authority to come to us and say you are in breach of the conditions. But this doesn't dissipate the fact that I've got a right to the water and that this water now is private when it comes into a canal. This is what we say.
But if the case is, if the proper inference is that there must have been consent to whatever use you had in 1888 via the canal, then you have to show that once those activities have ceased, the conditions would still allow you to carry on the use of the water that you have. Would that be possible? One way of
I would have thought that if there was any misuse of water, we would have been taken to task, because there is nobody to answer to that question. But if there had been anything irregular or disparaging, there would have been an action on the part of the state or any authority in existence. It would seem that there was nothing anyway on record for 100 years. So, and if I may, just to finish, I'm sorry, my lord.
If you could help me again with purpose. Do I understand you correctly? And that is that if you are making an application to the Supreme Court, you have to actually set out what the purpose of the use of the water is going to be.
Yes, my lord.
I'm having difficulty with the concept that if that was an obligation and the dyeing factory wasn't the purpose in 1888, how
Yes.
the water can lawfully be used for a dyeing factory when that purpose was never revealed.
Yes. Lord, it applies to the 1939 order also, because it is obvious that in 1939 there was no dyeing factory.
Yeah.
So it would apply to both orders.
But yeah, well, I understand you to be relying upon the 1888 order, because the 1939
Yes.
one, you haven't, the conditions haven't been complied with and is provisional. But do I understand you correctly? That is, that when making an application to the Supreme Court, you have to actually set out what the purpose of the use of the water is.
Yes, my lord.
And that wasn't done in 1888 for the present purpose.
Certainly.
Yeah. And what's the effect of that?
I would say, my lord, that if my contention is that if because we haven't got the 1888, which it is only surmising that it was for the purpose of a sugar factory, as per the pleadings, as per evidence of what we get, is that it was for an industrial purpose. Of course, it has evolved over the years, but my submission is that the water in this canal becomes private. If there was any breach on our part, it was up to the authorities to say you are in breach of such a thing. But the water, there is legality in our using the water, which will prevent the respondent for saying it is public. We say it is not public, it is private. There might be other avenues for the respondent if we are in breach, but not to dispute the ownership of water. This we will say is private.
Thank you very much indeed.
Just to wrap up on the issue of ownership of water, that is whether it is private or public, ground 2 speaks about the analysis of the Manga and Yemen case. I think it is important, it is at page 1334, the judgment of Manga and Yemen. And if I may, my lords, just in a nutshell, 1334. Both courts in Mauritius, that is the first instance and the Court of Appeal, my humble submission that both the judgments are flawed when they make reference to the judgment of Mega, because both judgments say that we apply the principles enunciated in the case of Mega, and we find that. My submission to your lordships is that they apply the wrong principle, because what was said by the learned judge in Mega is perfectly proper. I will submit that his analysis is perfect, and without going into the whole case, let us just go to page 1350. First paragraph, top of the page. If I may just read that. The short answer to the above contention is that the wording of sections 32 and 33, 35.2 of the Act, when read together, plainly denote that the water from any canal can become the property of an individual only if, in the first place, the individual has a good and valid title to the apportionment and use. This is what we say we have. The water in a canal cannot lawfully become the private property of an individual unless, first of all, the whole of the water has been lawfully drawn from the river in conformity with the Act before being put into the canal. This we say we have. It is the water which is apportioned from a canal which subsequently becomes the property of the individual. It is abundantly plain from the facts of the present matter, that is Magar, that we are not concerned with the apportionment of water from a canal, but from the apportionment of water from a river. And I totally agree with His Lordship when he says so, because when we read the conclusion of the Magar case is that the dam and the canal were no longer in use. My submission to the court is that both instances of the Mauritian court made the wrong inference because they went to the conclusion, not to the remarks of the learned judge when analyzing the proper method to be applied. So my submission is that if we apply the Magar test, it is obvious that once I'm lawfully extracting the water becomes private into the canal. My submission rests on all fours with what the learned judge had to say in the Magar case.
Could I ask you, Mr. Sauzier, about that last sentence in Mangard? It's abundantly plain
Yes.
from the facts of the present matter, we're not concerned with the apportionment of water from a canal,
Yes.
but with the apportionment of water from a river. Is that not true of the present case?
No, my lord. I would disagree with that, because when we go to the next paragraph of Magar, just that we have just read, the next paragraph, in fact, it is beyond dispute that there is no water flowing anymore into Yemen Canal, into Dam A. So in this case of Magar, the canal was no longer in use.
Thank you.
This is the difference between the two cases. My lords, the next point, I know we've reached almost time. If I may, I've got 5 minutes to go through one thing which cropped up whilst I was going through the various grounds of appeal, is that I'm going to make reference, as my learned friend did when addressing the Court of Appeal and the court, to the CWA Act, that is the Central Water Authority Act, which is at page 1156.
Sorry, page
1155, in fact,
Thank
is
you.
the Act. Now, when we look at page 1156, interpretation, section 2, we've got existing water rights. What is an existing water right? B, any right to any water from any river, stream, or canal. Being a right other than groundwater, we are dealing with surface water, which belongs to any person or body corporate other than a body corporate established by law for public purposes before the commencement of this Act. The Act is 1970. Now, did we have an existing water right? I will say yes, that the appellant number 1 at least, had an existing water right at the inception of this Act. And the respondent is proceeding against the appellant through the Central Water Authority Act to claim dues. Now, this point was addressed to the Court of Appeal. Why I'm saying so, my lords, is that when we go through the Act, when we read section 22, which is at page 1163, it speaks about existing water rights. And it reads, notwithstanding anything contained in this part, the authority shall not, except with the written consent of its owner, exercise any duty imposed under Section 20 or any power conferred under Section 21 so as to affect an existing water. So this will be an ouverture, if I may say so, to the rest of my submissions with regard to the validity of any claim against the appellant. If it is a convenient time, my lords, just before tackling this, the last part of my submissions, unless your lordships wish me to continue, I'm quite prepared, but this was the time agreed upon, I think.
That's fine. We'll take 5 minutes. Thank you, Mr. Sauzier.
Thank you, my lord.
Mr. Sauzier.
Thank you, my lord. So the next issue, my lords, is could the respondent claim any amount in any event to the appellant? Now, much has been said, my lords, as to the meaning of supply. I'm making reference to Section 20 of the Central Water Authority Act, which is at page 1160. Section 20, 1160. The duties of the authority. The 21, 20, small one, the authority shall be the sole undertaker for the supply of water. So I've stressed on the word supply before the Supreme Court. And your lordships will see that there are two regulations which are being referred to. The only one applicable in my humble submission is the Central Water Authority Water Supply for Non-Domestic Purposes Regulations 2011, which is at page 1198. 1198, which has been referred to by my learned friend in his able submission before the Supreme Court. And in this regulation, it is 2011, admittedly, but what we get, the gist of it, is at page 1199. What does the word consumer mean? You will see top of the page, commercial consumer means a person to whom the authority has agreed to supply water. I stress on the word supply. Middle of the page, consumer means a person, A, to whom the authority agrees to supply, the word supply once more. And if we turn to page 1200, bottom of the page is the word waterworks. And at page 1201, waterworks are defined, meaning the different systems of canals, conduits, mains, communication pipes, wells, dams, reservoirs, fountains, treatment works, and other appliances of the authority for supplying and measuring water, and includes all works, structures, rights of way, and other appurtenances held by the authority for the purpose of carrying into effect these regulations. And the last, if we turn to page 1202, your lordships will see that section 7 and 10, the consumer shall pay whatever before the authority carries out any works to supply water. Now, there is an interconnection with the supply of water and for the works, and also for the construction of any pipes or whatever. In our case, my lords, my humble submission that it is undisputed that the water flows through a private canal, a man-made canal, which is Réunion Canal. We are talking of surface water, and it is the property of appellant number 1. So in my submission, the respondent is barred from claiming any levy or duty or whatever fees to the appellant, number 1 and or 2. The point has also been taken, my lords, with regard to the fact that the respondent is a body corporate and it has been created by statute, as we are seeing now, for public purpose. So it can only claim from any citizen or body corporate such fees or charges which are prescribed or provided by law. This is to be found, my lords, in section 49 of the Act at page 1168, paragraph 49, regulations. The board may make such regulations as it thinks fit for carrying out into effect the provisions of this Act, and section 24A of the Act, which reads, the authority may receive revenue accruing from rates and fees to be levied under any regulations made under the Act. My lords, my humble submission is that it is admitted by the respondent, and I'm making reference to page 230 and 231. This concerns the evidence of Mr. Mataven on behalf of the respondent. Bottom of page 230, I was cross-examining on the issue of the agreed price of 150. When we turn to page 231, your lordships will see, first question, has it been gazetted somewhere? Not yet. So it was not gazetted yet, and I've made reference in my written case to the case of Audibert and the municipality of Kyopip at page 1326. For my little friend, it's tab 20, 1326, where the issue of the need of gazetting has been dealt with by the Court of Appeal. And there is no need for me to read through that. For me, it is an imperative, and this has not been done, and therefore, at any rate, there could not have been a tax or levy or whatever due claim by the respondent. The last point, my lord, which I will try to cover in 10 minutes, is the time bar. Now, it is to be found in the written case at page 1039. 1039, time bar. And the relevant article of the Civil Code is Article 2279. It is translated at page 1039, and I'll just refer your lordships to translation 2279, the third line, interest on loans and generally everything that is paid on a yearly basis or over shorter time periods are prescribed by a period of 3 years. The same point was taken in the case of CWA, that is Central Warfare Authority, against Société Rouillard Frères. It is at tab 24 for my friend, and at page 1365. 1365 in the bundle of documents. It is a judgment of 2013. And if I may, lords, in fact, the transcript of this case is reproduced at page 1041. Translation of the case, and reference is made at paragraph 74 of the same issue. Now, in this case, the plaintiff's summons was lodged on the 8th of January 2004. This point could be addressed if I was to fail on all the grounds of appeal. That is, if your lordships were to come to the conclusion that the water which runs into a canal is not private and that the CWA is entitled to ask for payment, even if no works have been carried out and no gazetting has been effected, then my submission would be that at any rate, the respondent cannot succeed for any claim which extends beyond 3 years from the lodging of the plaint. The plaint was lodged in 2004, and the learned judges, I'll come to the judgment later on, plaint lodged in 2004, and the pleadings were closed, making reference to some sort, I say the word confusion, which has been, in fact, the word used by my learned friend when submitting. The original case, that is the statement of claim, it is to be found at pages 15 and 16 of the bundle. In fact, exactly the same contents. It is annexed to the plaint with summons. The statement of claim, the first statement of claim, was lodged in 1996, the 22nd of October 1996. Your lordships will see that at page 18 of the bundle. Going through this, though, the second plaint with summons, that is the plaint we are dealing with, it mentions that on the 25th of July 2003, there was a letter to counsel and attorneys. It is to be found at page 46 of the bundle. Which informs attorneys and counsel, that the matter is going to be removed from, has been settled and now will be mentioned, so as to be struck out. We are talking of July 2003. The case is then postponed to the 4th of September 2003, 1.5 months after. On that day, my instructing attorney appears and the attorney on behalf of the respondent appears. 1.5 months after, I suppose he gets the proper instructions and the case is struck out, and we don't move for cause. We do not insist for cause. It is only on the 8th of December 2003 that there is an exchange of letters between my client and the respondent, where my client does not accept that the case be reinstated, obviously. So the present plaint with summons is lodged in January 2004. That is 4 months after it has been struck out. Now, my lords, in their judgment, first of all, when the case came for hearing before the first trial judge, she came to the conclusion that there was nothing due to the respondent because no works had been carried out, and that it was, so the appellant before you today won the day as far as the issue of payment is concerned. Then we both parties appealed to the Court of Appeal in Mauritius, and you will see, my lords, that the judgment of the Court of Appeal is at pages 769 to 778. A very concise judgment where, although this issue of time bar is addressed by myself very briefly and by my learned friend very briefly, their lordships do not even address this point, and they just order in the last part of their judgment, Your Lordships, which is at page 778, line 21, 20, 24, we accordingly order the respondents to pay for the water consumed as from January 1994. There is no analysis of the point, there is nothing. This point was raised, and it was not specifically raised in the respondent's ground of appeal, but this point was addressed both by my friend Moulan and myself. And their lordships, in their wisdom, chose not to analyze, simply to order the appellants today, even appellant number 1, who had no dealing whatsoever with the respondent, whatever dealing which could have existed between the respondent and one consumer was with appellant number 2. So my submission is that the lordships were wrong not to address the point and were wrong to order payment from 1994. If the appellant was wrong or did not win the day, the only period of time we could be penalized was for 3 years going back from 2004. This is my contention, because Your Lordships, we see that could there be, the last question, an interruption of the prescription? And there are 2 articles of the Civil Code which deal with that. First of all, Article 2244, and Your Lordships will see that it is highlighted in paragraph 75 of the written case at page 1043 of the written case. And I refer to Article 2244 and 2247. More specifically, if the assignment is null by default in form, if the claimant withdraws his request, then the interruption is deemed to be void. And reference has been made, my lords, to a number of French authorities, which there is no need for me to go through. They all speak the same. They have been translated from pages 1044 to 1045. What constitutes an interruption? My lords, I've tried my level best to be in time. I believe I am, because if we take the 5 minutes allocated for a break, I've done my 1 hour and 30 minutes.
Lord Jones, I think you're muted.
Thank you.
Yeah. Thank you. No.
I think, sorry, I think you're still muted, Lord Jones.
Mr. Sauzier, my third
Yes,
attempt.
yes, I can hear you now, my lord.
Forgive me, and I'm grateful to my colleagues for pointing that out. We're grateful to you for your submissions. We have no questions for you at this stage.
Thank you, my lord.
Thank you. Mr. Moulin.
Thank you, my lords, my ladies. At the start, my lord, my ladies, I would like to say that at the heart of this appeal lies one central question, and that is, may a private company claim an absolute ownership right in surface water, as distinguishable from groundwater? Rights which the respondent submits are the public domain are inalienable. They may not be the subject of private rights. Now, that right to water concerns one of the most important rights in Mauritius, in a country like Mauritius, which has finite supplies of fresh water. Now, other countries may have it, but in an island which is only dependent on rainwater, we're a dot in the island. And the conservation of those water resources are absolutely essential for us. Now, this principle that water is inalienable and the property of all has its roots, I submit, my lords, my ladies, in Roman law, and finds its application in civil law, and I understand, I'm not very well aware of it, but other common law systems. Now, the board will have to decide, in my humble submission, whether after 1863, being the enactment of the Rivers and Canal Ordinance, and in the absence of a concession, we do not have a concession, we have a water right granted, where the right of use of water granted by the Supreme Court, which order is not retrievable, is a property right. And with property, my lords, my ladies, I mean three attributes. Firstly, the right to use the thing, the jus utendi. Secondly, the right to enjoy the fruits of that thing, the jus prudendi. And lastly, the right to dispose of that thing, the jus abutendi, which may be basically either you may destroy it or sell it. It goes as far as that. And with those characteristics of the right of property goes the absoluteness conferred by the civil code to that right of property. I would wish to make a distinction. I'm not extremely aware of property rights in other systems, but we do not have the equitable rights that other legal systems have. Our rights are legal or do not exist. Now, flowing from the above, so it is our position that a right to use water granted by the Supreme Court may not be a private property right. And with that, as I say, all the appurtenance rights of sale and user without the consent of any person. It's the position of the authority created in 1971 that the powers of the state were devolved upon it by that act. I will not read it, but I believe it's fairly obvious. And therefore, it is common ground that between all the parties that all rivers and waters in Mauritius form part of the public domain. I think there's no issue on that. The problem will be, is the right to draw the water a right which my learned friends' clients have been able to establish being their own without any condition, or that they have prescribed. Now, following the above, the authority submits that if the law does grant rights of use over waters, and I think of there in Section 12 of the Rivers and Canals Act and Article 644 of the Civil Code, those rights of use may not constitute private property rights to be disposed of at will. I will come back to Article 644 in due course. At the outset, I'd like to put forward what I believe to be an inherent weakness of the appellant's case. We respectfully submit that Ciel cannot put forward, without contradicting itself, that all waters are public property, but it has a private property right over the waters in the canal. Being part of the domaine public, surface water can never be private property, whether by title or prescription. And after being drawn in the canal by a lawful right, it may be used for the purpose for which it was granted. And this requires, firstly, is conditional prior court authorization, which necessarily implies that the right to draw water is subject to it not being dissociated from the appurtenant land, obviously. And secondly, that the usage remains the same. And at that point, my learned friend referred to note 166 and 173 from Dalloz. And I'll translate quickly that note 173 at page 1421. When a canal or channel appears to be the exclusive ownership of a private owner, or even the common property of numerous private owners, but excluding others, the riparian occupiers of the canal may not assert rights to use those running waters granted upon them by Article 644 of the Civil Code. These waters remain therefore under the exclusive ownership of the ones who made the canal. And it goes on, case law has therefore held that Article 644 of the Civil Code does not apply to man-made canals. And I submit that straight away this is inherently incorrect. Firstly, the 1888 orders and the 1999 orders start as follows. And there, we don't have that 1888 order, we remember that. But let us just try and see what Mr. Francis Hall said in his report, document D, and I ask your lordship to turn with me to page 431. You've read that part, my friend has read. Their sills should be at the same level and dimensions in accordance with the relative volumes of the rivers as established by the reporter in his division. Now, the reporter at that point is Mr. Maillard. 25 for the Ruisseau Saint-Martin and 42 for the River Tatamaka. See paragraph 2 of this report. And allowing the 22.035 shares, which belong, there's a comma, which belong to Reunion and are returned to the river. To make up for the small volume of water allowed to maintain the bed of the river Tatamaka, while surplus waters are being taken. The comma is before and after which belong to Reunion. Now that is not proof by itself that those waters were returned to the river or not, but I believe my friend's case is as follows. So if there is, and I believe this is probably the only time we will see that, it is also said that they will return at page 43 or the 22.035 shares, which are his property, but it could be equivocal. But I believe that at page 431, there is no doubt about it. One of the conditions, at least, that we can see from a document read by somebody at the time is that there was a need to return to the river. And if that is the case, then condition 1 of the Supreme Court order at page 437, that the water drawn for the river Tatamaka and rivulet Saint-Martin shall, after having been made use of, be returned by the applicant undiminished and unpolluted to the aforesaid river and rivulet respectively. Now those two conditions must flow from one another, and I have little doubt that that condition is not being fulfilled. And for that reason, I state that the case of the appellants is flawed in that respect. And there I move on to the next point I want to make regarding note 173 of man-made canals.
Can I just ask, is there any provision that states what the consequence is of a person to whom a right has been allocated by the Supreme Court not complying with a condition? What are the consequences of failure to comply with a condition of the grant of water?
The consequences, my lady, would be that in those specific circumstances, the person responsible for water rights before the government of Mauritius, the state of Mauritius, and nowadays the Central Water Authority would take action against those persons to stop them drawing water. Your ladyship will remember that I have amended my case to ask for an injunction restraining the appellants from using that water because they are breaching those rights. May I continue, my lady?
Well, but does it make any further drawing of the right of the water an unauthorized drawing?
In my humble submission, it would, my lady. You would not, if you're the very right to draw the water is subjected to conditions that you do not fulfill, then obviously the further right granted in 1939, also subject to the same condition, would be illegal. And in those conditions, the appellants may not claim to have a right to bring the water in their canal. Your ladyship will remember that's an important point you're saying, and maybe that's an appropriate time just to look at a small diagram. Your ladyship will remember that we have a diagram at page E17, page 443, document E17. You have the dam, and in the dam, you see the canal to the factory. And at the same time, that is a document of 1987, my apologies. It was the documents prepared by the Water Rights Administrator at the time, Mr. Kopemutwe, if I'm not wrong, when he was looking at those various rights. You see there that there are two openings on the masonry dam. Now, the first opening is for the normal flow of the water, and the second one is for the canal. And your ladyship will remember that the right to draw is by way of a metal plate. And the metal plate is open for 9/10. So 1/10 goes to the river and 9/10 go to the canal. My lady, if that is the case, with the necessity to return the water, that condition could never be fulfilled. And that condition being breached, by necessity, the right to draw water must be now a right which is not exercisable by the appellants anymore. There's a further reason, which is the purpose, but I'll come to that a little bit later. If I may, my lady? Thank you. The next step I was saying is section 174, note 174 of Dalloz at page 1421. And it reads as follows, 174. Le propriétaire du canal n'est pas tenu de restituer les eaux à leur sortie du canal pour qu'en profitent les riverains inférieurs. Translated, the owner of a canal does not have to return the water when it leaves the canal so that the lower riparian owners may use it. Now, this is, therefore, the fundamental flaw in the appellant's case. If they had the right to draw the water, it was subject to a right to return, an obligation to return it. Because if my learned friend is right, he had never any obligation, his clients never had any obligation to return those waters. And the note 170 is very clear about it. This is why he tries to establish that he has a private right to those waters in the canal. I propose to structure my submissions in the following manner. Firstly, the jurisdiction of the Supreme Court of Mauritius. I believe it's of some relevance to this present appeal. Secondly, the analysis of the proprietary rights in water and the scheme of the applicable legislation. The evidence on record will be the third point I'd like to tackle regarding the water rights granted to Reunion in 1888 and 1939, and how any rights of use under those two orders may not be relied upon by the appellants for the present user that they make of it. Lastly, the issue of prescription, and the last point I will address is the issue of claim for payment of water. And I will try to explain why I do not agree with my learned friend on that point. Now, very briefly, my ladies, my lords, I would like you to remember that water rights come in Mauritius as a colony of France from the laws established under the feudal regime. Lordships and ladyships are aware that after 1789, the Assemblée Constituante was made. And on the famous night of 4th of August, the whole of the feudal regime was abolished, except one right, and this is the water right. The clergy was heard, the nobility was heard, the tiers état was heard, and all the feudal regimes disappeared on that night. The king took some time to accept it and signed it in October. The important part is, why did they not change the water rights? And the reason is found in the fact that they felt during those discussions of August 1789 that it would be too dangerous to change the very basis of agriculture in France, the right to water, essential to everyone. They could do many things, but not change that part, even for the nobility, for the tiers état, or for the clergy. This, therefore, brings us to the fact that a land court had been established, known as the Tribunal Terrier. Now, Terrier, coming obviously from terre, and being the feudal land court. In 1810, the Île-de-France became a British colony and was renamed Mauritius. In the Traité de Capitulation, all the persons living in the island were allowed to keep their religion, laws, and customs. An extraordinary law, I hear, but this is the fact. So the newly enacted Civil Code continued. And by Ordinance 13 of 1832, at page 1148, the competence of the Land Court was transferred to the Governor in Executive Council. Now, in 1863 will come the Rivers and Canals Act, which is Ordinance number 35 of that year. It is at tab 1, page 1096 to 117, and it was revised, and the revision is at tab 2, page 1118 to 1143. I pause there for a short while just to explain to your lordships why, and ladyships, why what we see today is not exactly the text of 1863. My learned friend and I did not address that, but I think it's common ground that a revision of law unit was set up in 1974 for the purpose of preparing revised editions of the laws of Mauritius. And for that purpose, they had the right to omit the preamble to an enactment, redact it, consolidate it with all necessary consequential changes, enactments in pari materia, reorder or renumber any part of an enactment, alter the form, etc., etc., etc. Basically, the 1863 law was put au goût du jour in 1974 and is the actual rivers and canal. But to all intents and purposes, the 1863 law is exactly the same as was intended to apply today. There has been nothing. At some point, there is in the section 51, I believe, of the Act, that the rivers and canals was to be repealed. It never happened. Now, we start, as my learned friend has stated, by virtue of section 1 of the rivers and canals, which states, which now is the section 3, that all streams and rivers are declared and enacted to be public property. My lords, my ladies, I pause there just to say this is not something that happened by chance. And when we turn to the supplementary bundle prepared by, which I have put forward, you will see the report of the Procureur Général, Mr. Dixon. The Procureur Général was the old Procureur du Roi, therefore the Attorney General, as we would call him nowadays. And in what Mr. Dixon said when he explained the objects of the law, we will see at paragraph 24 of his report to the Colonial Secretary, which is to be found in the typewritten note at page F74. So I believe it's 74 of the supplementary bundle. We read the following. Although the older decrees above supported to some extent the former view, that is basically whether there could be private property in water or not, the latter is thought to be more correct, reference being had to the great natural law of necessity, which in a tropical country forbids that one of the chief necessaries of life to every member of the community should belong to the crown in property. While again, the fact that the crown had been in use to make grant of water gratuitously was more suggestive of a discretionary power to distribute common property than a power to dispose of a right belonging exclusively to the crown. The principles of the Roman law, which was the base of the formal law of France, supported this view. And we read straight away from Justinian, et quidem naturali iure communia sunt, omnia haec, aqua profluens. Flumina autem omnia publica sunt. And obviously, those common goods are the natural right of all, running waters. And it is true that all rivers are common to all, but also of public property. So the Justinian Code was specifically the reason why the preference made by the legislator, and this is in 1864, as Mr. Dixon will tell us, to make all those waters public property. There was always this problem in France between whether a river which was non-navigable ni flottable was or was not public property. This resolves it. Every single water in Mauritius is public property, subject to this act. And as rightly pointed out, what will the law allow? It will simply codify in the whole of sections 5 to 20. When I speak of 5 to 20, I believe it's the old law, not sure what it would be under the new law. But it codifies first the rights of the borderers to use the water. And what are those rights? Domestic purposes, for their animals, for themselves, to draw water. This is agricultural France in the 19th century, and it is perfectly consistent with Article 664 of the Civil Code and the rights which are conferred upon those persons. If I may ask your Lordships and Ladyships to turn to that article, which is to be found at page 1174 of the Table of Authorities. There is obviously one small private property conserved by the law that is for a spring. So for a spring, which is on the land of the person, it may constitute private property. That is not at all an issue here. That would be, in my humble submission, the only type of private property in water in Mauritius. 644. Celui dont la propriété borde une eau courante, autre que celle qui est destinée, déclarée dépendance du domaine public par l'article 538, au titre de la distinction des biens, peut s'en servir à son passage pour l'irrigation de ses propriétés. Celui dont cette eau traverse l'héritage peut même en user dans l'intervalle qu'elle y parcourt, mais à charge de la rendre à la sortie de ses fonds, à son cours ordinaire. I'll try to translate. I believe
but assist Mr. Moulin, because not all the members of the panel are fully fluent in French. So we'd be
I do. Yes. So I will then, in future, I will only refer to my translations and see where they are.
Thank you.
So the translation is at page 1059 in footnote 17 of my case. Any person whose property is found on the border of running water, other than that has been declared to form part of the public domain until Article 538 under the title of the distinction des biens, may use it as it flows for the irrigation of his properties. And you will see that at the end, there is, they may use it while it goes through its l'héritage, le fond, its land, but they must when it goes out of his land, give it back to its natural flow. So it may be diverted on the land for certain purposes. If you have a river entirely on your land, on both sides, you may divert it if you want so as to use another part, but when it leaves your land, you must bring it back to its natural flow. That is what Article 644 establishes. And this is, I think, the more important part of the law. It recognizes without any difficulty that this distinction, which are put forward by the Civil Code, it is, as Article 539 will say, if your lordships would wish to read it, I haven't translated it, but I'll try to do so. 1172. Tous les biens vacants et sans maître, etc., appartiennent à la nation. All vacant goods and without master are goods of the nation. All property without master. Now that reminds us, isn't it, of the very definition of a res nullius. Now, any res nullius is under section 39 to be the property, 539, sorry, to be the property of the nation as is put forward. Now, how could water, which is expressly declared in Mauritius by an act of parliament to be public domain public, they use the French word to explain it, how could it, after the fact that this, even if you consider that it is a res nullius, you cannot appropriate at any point in time, how could it become private simply because it runs in the canal? It only becomes private if it is used for the purpose granted. The water is always public. And a right of use is granted by the Supreme Court. Exactly what was done in 1888. And it would go against the whole flow of the Act and against the grain of the Act. It would actually, destroy the Act to allow simply someone who cannot prove his title, and proof is on him and not on us, who cannot tell us what was the use at the time, and who can simply say, this is the share that is there, to be able to dissociate it from the land where it was drawn and say, I may use it for whatever purpose without returning to the river. In my humble submission, my lords, ladies, this may not be the case. You must, in all cases under the Civil Code, return it to the river. And in those cases where you're allowed to use it, you must use it for the purpose granted to you. It cannot be otherwise. And saying I do not have a title is of absolutely no help to any person. Either they can establish it or they cannot.
But if you use the water for irrigation, you can't return it to the river. It's consumed. So it can't always be the case that the water has to be consumed, has to be returned to the river.
My lady is absolutely correct in her in her statement. And in such a case, your lordship will remember that when it is consumed, you must only consume that which the law will allow you to do so. And if you affect the rights of the lower owners, they may come to court to ask that this be reviewed. This is exactly the purpose which is set out in the Act as I said, in sections 5 to 20, how the borderers may apply to court to have their rights reviewed. If your lordship would wish me to go there? No. So these rights of the borderers are protected by the rivers and canals. And if ever somebody draws too much water for his own irrigation, he has a problem. Now, my lady, this may be anecdotal, but it is important to read it. I'll try to explain why. One of the things you will see, is that concessions are kept. I believe it's section 10 of the former law. Now, when concessions were kept, one of the matters which happened is they say that if you can't find your title deed of concession, it is presumed to be for non-agricultural reasons. And Mr. Dixon explains it very clearly. He says, many a proprietor would come and say, well, I do have a concession. Now, a concession, milady, was granted by deed by the king, obviously. So I do have a concession. The colonial secretary has assigned a concession to me. I can't find it, and I can use it now for the irrigation. Now, this changed because the problem is, in the beginning, it was said to be deleterious to sugarcane plantation to have too much water, until it was found that, on the contrary, it was very beneficial to have to irrigate it. And at this point, everybody started drawing water. And whenever the colonial secretary would come and say, well, would you stop? Say, well, I have a concession. So the law enacts, and it is there, that when you have a concession, it is bound to be for any reason except irrigation, to prevent the abuse your lordship has exactly pointed out. And if there is a problem, you may address yourself to the Supreme Court. We'll look at the rights of the borderers who are lower down in order to allow you to draw only the share of water you are entitled to by reason of the quantity of land that you own.
And can the Supreme Court review an appropriation of water to a borderer at any point, so that all rights to use water are subject to an order which may be made at any time by the Supreme Court in pursuance of its jurisdiction to allocate water rights between borderers?
Yes, milady, I believe this is so. I think there is no difficulty when you read the Act to take exactly that point from there. And I believe that this is a normal right which flows from being the res nullius that we have seen just before. It cannot be otherwise. If it were otherwise, milady, then we'd be able to allow someone with a right exercised for more than 30 years to come and say, well, I do have that right, and the Supreme Court may not change it. My learned friend have shown you the CWA Act, where the existing water rights are preserved, and therefore I cannot change an existing water right without his consent. So in those circumstances, well, who may do so? Only the Supreme Court. And it must be the economy of the Act that at that point, what is being sought to be done is to preserve water resources.
Indeed.
And for that purpose, and for that purpose, milady, the Supreme Court has the jurisdiction, as I said, of the Tribunal Terrier. Well, we may go there, milady, to show that the jurisdiction of the Tribunal Terrier was absolute, and the Land Court could grant whatever share to whoever and change it at will. Now, if it is necessary, I'm prepared to do that, but I think that the law itself, when you read it, does leave that open. It has never been adjudicated as such. It hasn't come, but you will see that the principle in Despecie and Carsonac was in fact put forward quite clearly.
Yes, so that whenever this situation exists, and I think it comes from Roman law, you cannot have a property right because it's always subject to the court reallocating the water use in accordance with current needs. For instance, if somebody sets up a mill, a water mill, needs the water to grind flour, that would be one of the reasons in this country why you would need to have an adjustment of water rights.
I may not have put it in clearer terms, milady.
Thank you.
Sorry. Just, could I get your help in relation to section 12, which is at 1122? Which gives an ability for a share of the water, depending upon the quantity of land capable of being irrigated by it.
Indeed, my Lord Stevens.
Yeah. So, and that is the quantity of land owned by the borderer. That is, it can't be any quantity of land. It has to be owned by the borderer.
This is exactly correct, my Lord.
Yeah.
This is the only way you may read it.
Yeah.
And if your Lordship is interested in the Dixon report, it says exactly that, which is why, in fact, I found it interesting to give that 1864 document, which I felt would be of assistance to explain those issues.
In arriving at the 1888 order, would they have taken into account the quantity of land capable of being irrigated by reunion?
My Lord,
in order to arrive at the share.
My Lord, this is the exact question that I put to the witness in cross-examination, and his answer is he supposed it to be so. And this is the very point that I agree with. There must be two reasons for that water to be taken under Section 12. Firstly, you needed to irrigate your land. Secondly, the river may support that user. And that is dependent on two things, is the amount of water at the time. Your Lordship will remember that we're in winter now. The summer rains have stopped, but this is also the time where water may be used for irrigation of some parts when you start cutting sugarcane, which will happen in June. So after you cut the sugarcane, you'll start planting shortly thereafter. Now you will need, therefore, water in the dry season. So the user of water in this country will depend on the dry and rainy season, and will depend at the amount of water available at the time of the dry or rainy season. So when the authority will be asked its views, it will look at those two matters: which season we are in, at what time you require that water, and how much water, how much land you have. And lastly, what is the need of the lower riparian owners? These, my lords, I think, would be the points on which a court or the authority first would be asked to give its views, and the court would then have to homologate it or not.
And the share is a share in the flow of the river, rather
now,
than...
Share,
yes, sorry.
Share is a strange word which is being used, and it's a good point just to say so. Share in Mauritius does not actually mean that you divide the water in so many different parts. It actually means cubic foot per minute. So when you read 22.035, it normally means CFM. Now, there are exceptions, but I believe this is the manner in which until the 1950s, this was quantified in Mauritius.
And so, therefore, if you get, say, for instance, a 22% or 22 portions, 22.35 portions of these two rivers, you transfer that to what was the flow. You then calculate how much that is in cubic foot per minute in 1888, do you?
Indeed, my lord.
And then what happens when the flow of the river decreases?
Now, this is exactly the reason why Mr. Hall came to court. If your lordship will read his statement, Mr. Hall says the following at page 429, paragraph 2. After a series of gaugings, the report has attributed 42 shares of cubic foot per minute to the river Tatamaka and 25 shares of cubic foot per minute to the Ruisseau Saint-Martin, a total of 67 shares for the two rivers. So the reporter said at the time there were 67 shares, 67 cubic feet per minute going through Tatamaka and Saint-Martin. And there it says at paragraph 4, the share of Réunion factory is now much less than stated above, as the figures arrived at are based on gaugings established in 1888. The water system of this island has since decreased considerably and is yielding a much reduced volume compared to that of 1888. The factory has therefore now at its disposal volume decidedly under 22 CFM. So your lordship is absolutely right that the reason for the surplus waters is because even those 22.035 shares could not be satisfied in 1939. Because there was a decrease of the amount of water.
I just have difficulty envisaging how, if one person is, say, entitled to a particular, say, 100 cubic feet per minute, and the flow of the river decreases substantially, and they still take out 100 cubic feet per minute, how that doesn't adversely impact on other people further down the river.
That's a very good question, and I'll answer it, Malord, if I may, for where we are. Now, remember that Vakwa is in the center of the island, in the absolute center of the island, where Réunion is. And people do not live on the borders at the time because of malaria. They would come to the upper country, to the central plateau, as it is known. So Vakwa, Phoenix, and Kyope were the three main cities where people lived. It was actually essential for them to obtain their water. A water system was put in place, which is the Maro Vakwa, which brought potable water, stopping people from needing to take it from rivers. For that reason, the city of Vakwa took less water, which therefore enabled Réunion to draw more water, although, as you rightly say, they could not draw the entirety of its 22 CFM, because water which was being, at the time given, was being given to the public by the municipality. In fact, there were no places where you could obtain what we have today, which is water everywhere. There would be the fontaines publiques, where people would go and take the water that the municipality would bring to them. That was the manner in which it used to work in those days.
Thank you very much indeed. Thank you.
Can I just check a point? Are we assuming that the 1888 order and the 1939 order are orders of the kind that are referred to in section 12.3? Those were orders assigning, pursuant to section 12.3, the portion of the water to which the borderer was entitled. Is that right? Or were they under some other power?
It does not say so expressly, and they do not say either under which section of the Act they went. But in my humble submission, it would not be section 12, because it would be only for irrigation. But what is probable is the following, is that they had a right to draw water to irrigate their land. But as I've just said, the Central Plateau is a place which is where, we're at 400 meters above sea level. There's condensation and there's quite often rain. So you do not need that much for irrigation, as a matter of fact. But the amount of water that we entitled by reason of the amount of land that you have could be transferred to other users. And Mrs. Boudou said in evidence that water for sugar mills was being drawn in to be used within the factory for to cool down the machines, and in order to obtain the sugar once the syrup had been made, and afterwards was returned with the excess condensation that was being made. So there was in fact a little bit more water than what was being drawn. It was not adverse to the rivers, and such user could be tolerated in an agricultural country for that purpose. It was not for irrigation, but you would not lose water, which meant that people below were not affected. That would have been in 1888 if it was for that purpose, which obviously I do not know. I'm only surmising.
Right, so you have 500 arpents of land, but you don't have to, use your entitlement to water across all that land. You can just use it in a factory which takes up only, say, 2 arpents of the land. But then what happens if you want to sell that factory to somebody else, but not your whole 500 arpents of the land, but obviously the buyer of the factory needs to have all the water that's used to work the machines in the factory. That's what's puzzling me at the moment. How does the system apply in those circumstances?
It does not, milady. It may not apply in that manner at all. The user granted by the Supreme Court is for a purpose. It's a right to draw water for a reason. And that reason here is one we know for 1939. As I say, I only surmise for 1888, but it's a reason for 1939. So if someone says, I have 500 arpents of land, and I can draw that water because I'm not using it and I'm not affecting anybody else, so allow me to use it. And the court says, well, yes, there's no issue, we'll allow you to do that. Although it's a portion of water, not for strictly agricultural purposes, but the fact that you're not affecting anyone, we authorize you to do so. And that is exactly the kind of right that the colonial secretary would grant, would look upon favorably, and would say, well, it doesn't affect anyone, we may give it. But when you try to dissociate it from the land, it doesn't work anymore, milady. You may not do so. It was for the specific purpose of 1888, well, I don't have it for 1939. For that specific purpose, that could work. But when there was a change, you must apply to the Supreme Court again. And in fact, to be honest, the appellants do not really believe their own case, because they did ask for those water rights. And they never behaved as if they were the owners of those water rights. But I'll come to that a little bit later. But they simply could not sell those rights with the factory. These did not depend on the 14 arpents 16. I mean, if I just stop there for a minute, you will remember that Mr. Noel said that 1 arpent had been sold to build a supermarket there. As I say, it is in the center of the island. In such a case, maybe, if 1 arpent was sold, let us accept the position of my learned friend that the 14 arpents 16 entitles him to 22.035 shares in the water. Then what about the 1 arpent? How can he even come to say that having 1/14 less of land, he's still entitled to the same share? That shows why it doesn't work, really. My answer to your leadership.
Sorry, if the application isn't under section 12, what sections is it under?
I believe it was a section 80. It would have been a section, section 77 application at the time, and 78, and now section 80. Où se trouvent les actes of parliament ici? Yes, exactly. On the section 80, subject to section 5, all questions, page 1138. All questions to any concession or any right to water from any river, stream, run of water or canal shall be brought before and decided by the Supreme Court. So it doesn't stop it to being agricultural only. Any other right may be brought in. The section 12 right would not have applied specifically, but would have been relevant for the court to make its decision when it decided how to apportion the water in 1888. That was what I was trying to say. But it is therefore the issue of jurisdiction, which is indissociable of the very nature of the right to water, which is what I wanted to point out. And I believe that I have done that exercise, and I may now move on to the next point.
Before you do that, Lord Burrows has a question.
Thank you, Mr. Moulin. Let's assume that the Supreme Court granted certain water rights for the purpose of a sugar factory in 1888. Then let's assume that the owners of that factory wanted to sell that factory. Would that require going back to the Supreme Court in order to effect any transfer of the water rights? Or in your submission, would that follow automatically?
My lord, the question would go with the land which is exchanged. If the water rights are pertinent to the land, if the land is sold with the water rights, yes. But there must be the very land for which those water rights were granted. Now, I do not know what were the water rights of 1888. Let us say at the time, if a sugar factory would come and say, I own, 1,000 arpents of arable land, and I would wish to be able to be granted so much water for irrigation. The court will look at it and say yes or no. Now, if they sell the factory with only 5 hours...
Can I just interrupt you for a minute? Because I understand that, but I thought you just submitted or told us that where purposes change, one is required to go back to the Supreme Court. And what I'm suggesting is, if the purpose was actually changed so that, let's say, the new owner changed from being a sugar factory to being a dyeing factory, would the new owner not have to go back to the Supreme Court?
Indeed, my lord, and that was I was coming to say that if the same amount of land was there, I believe that what we need is simply a confirmation when the land changes hands. But for example, in Medine Sugar Estate, it was found at page 1281 when that riverains can exchange their waters between themselves. But if you cannot alienate the water from the land, and if ever you change hands, my submission is the status quo is reversed and it is restored, and we come back to having to ask again a new authorization. The authorization granted then lapses, and you must go back to the Supreme Court. That would be my answer to your lordship's question.
Thank you.
So is the sale which took place in the present case with water rights something contrary to normal practice in Mauritius?
Not only contrary to normal practice, it's illegal, milady. This is my submission. And it may be opposite now simply to read what it is. When they say they're selling those rights, well, what rights, what do they have to sell? Well, first and foremost, before selling something, you must have something to be able to sell. And let us read exactly what that document says. Où se trouve là le titre de refac? Document K, if I'm not wrong, that's exactly what it's document K, at page 496. It says at 495, observation is made here that according to a report of division of waters of the rivers Tatamaka and Saint-Martin made by Mr. Maillard, Arpentant-Juré, the 28th of February, 1888, it has been extracted literally what follows. Now then we see what there is, but let's just look at what is supposed to come from that 1888, the second paragraph. Plus tard, par jugement rendu par la Cour suprême, SCR 2041, rendu le 13 février 1939, la sucrerie de Réunion fut autorisée à épuiser 9/10 des eaux de la rivière Tatamaka. Later, by judgment of the Supreme Court, SCR 2041, delivered on 13th February 1939, the sugar factory of Réunion was authorized to draw 9/10 of the waters of River Tatamaka and the whole of the rivers Saint-Martin, upon condition, however, to restore them in their integrity and unpolluted. Now, how could in 1888 Mr. Maillard make a declaration for 1939? That shows by itself what is an acte authentique. It is a declaration of the parties. Now, I may declare whatever I want. I may declare to be owner, of Parliament. But if the law does not give me the right, what can I do about it? And this is the simple fact we are here. Two private parties sat down together and declared to themselves that those waters may now be dissociated from the fond upon which they stand and be sold between themselves. Now, that is not possible, my lady. This is my humble submission to the board. It is that very act which I contest, trying to put forward that document as being the source of the rights of Réunion is incorrect. It could never have operated to transfer any right, because that is prohibited by law.
And I do apologize, but I understood these to be what the Supreme Court does is to give a right, and that right is a servitude and it attaches to land. And so I'm not certain why you can't assign that right with the land, so that I can understand if you change the purpose from a sugar factory to a dyeing factory, that would cause, may well be outside the right that you've been granted. But why, if you had maintained a sugar factory, why can't you just assign the right to
because
the
land at that point was not the same, my lord. The right upon which was granted was for a larger plot of land, which was irrigable and used for certain purposes. If it is going to maintain the same sugar factory, I do believe your lordship is correct in his analysis, because then you would not change the user, and in fact, Refak was able to do so. But trying to say that these water rights are absolute is the point I was trying to make. This is what they may not do.
But I'd understood you to be saying that if you had 500 arpents, you could acquire a certain share of the river. And then once you'd done that, you could use it for your sugar factory if you so wished, so long as you told the Supreme Court that's what you were going to do.
Indeed, my lord.
Right. And there's nothing prohibiting you from doing that. So that in fact, all the water could be used, could have always been used for the sugar factory. We just don't know, but it might have been. And so that would be a right which was crucial to the sugar factory, but you say it was also dependent upon you continuing to own the 500 arpents. Is that right?
This is what I was saying, my lord. Yeah. And I believe that at the point that they separated it, they should at some point at least have gone back to the Supreme Court to explain it. Because if not, in theory, you could reduce it to only the factory. And where do we end there? And whatever other persons, what do they do? Do they come and say that the right has somewhat changed? If there's going to be a sale where you sever the origin of the water from its user, then the Supreme Court sanction must be had. Otherwise, it would allow the users just to move on without the sanction of any person. So while I do understand your lordship's point, that if I maintain a sugar factory, it's a permitted user, and if I do not affect anyone, it is permitted. But is it not at least necessary that somebody goes back to have a look at it and decides whether that user is in fact correct? What the water administrator of the country, my client, has to say about it, and what are the future resources? Your lordship will remember that the exchange of correspondence, my client was not sure whether they would grant that amount of water, because they did say they are having problems with the Marovacqua system, and they might very well have to use treated water from the river for the Vacqua system. So therefore, they propose to give only a water right for a limited number of years until they were able to review it later. I may find the point later. I'll give it to you. But to come and say that you have a right to assign, I entirely agree with your lordship. If they keep the same amount of land, yes, they must. That is not a problem. And for the same user, then the land are assigned with the water. The water is part of the land and assigned with it. The user goes with it. But then when you start restricting the amount of land, in my humble submission, my lord, you must go back to the Supreme Court. May I draw attention to, it's ex parte Colin at page 1266.
I'm sorry, could we have the reference again, please?
1266.
Thank you.
If I may read, my lord, the second paragraph, the object of the application before us is clear to alienate and alienate permanently the portion of water assigned by the land court to Solferino. The estate Solferino was a sugar estate on one side of River Cogliano and attached it to Pierrefonds on the other side. And I think that such a sale involving such a permanent severance of the land from the assigned share of water is contrary to the spirit of the ordinance and to that of Article 644, according to the interpretation of which commends itself to my judgment. It may be true that, as things stand at present between the proprietors of these two properties, no loss would be felt by the one, while there would be an increase of facilities for cultivation to the other as a result of the proposed sale and purchase. But the assignment of water to riverains under the ordinance, I regard as an assignment to them qua riverains or proprietors and not them qua individuals. We have to remember that in time to come and under other and future proprietorship, these conditions might be reversed and a property standing in need of it might, if we authorize the proposed arrangement, find itself permanently deprived of its assigned share of water. I hope this answers the question of my lord. I was going to go briefly. I didn't sit down yet.
That might be a convenient point. Yes. We'll resume at 2 o'clock, please.
Thank you, my lord.
Thank you very much.